Hey y'all, welcome back to my channel. Thank you so much for tuning in. I am Kodani. If you guys are new, then please do subscribe and click on the gray bell so you get to see me more often. And if you guys are not new, thank you so much for coming back for yet another video. Again, this is Legal Chats with a Baddie, a series on my channel where we speak about the law in a more realistic way. And in today's video, we're going to be doing that. And if you know somebody who should draft a will, who should have a will in place, if you're in a family that you know something might happen in your family and you guys might fight over property and assets and all those things, please share this video and share this information with other people. Without further ado, let's get into who makes a will. I'm gonna like this person is referred to legally as a testator, somebody who drafts and makes a will. Now, for a will to be valid, it has to be in writing and it has to be drafted by somebody who understands what they're doing. So they have to have capacity to draft a will. Now, capacity means that you have to be 16 years of age or older, and you must understand the nature and the consequences of what you are doing, the nature and the consequence of writing, and it must be signed by the person who makes that will. If that person cannot write or sign, that person can have somebody sign on their behalf. Now, there are two types of situations. You can die with a will, you can die without, or sometimes you can die partly with a will and partly without. I'll get to that. Now, when you die without the will, we say that you have died intestate, which means that you died without a will. There is nothing that actually tells people how to administer your property or your money or whatever that you have. That's dying intestate, and that is governed by the Intestate Succession Act. If you die with a will, you die testate, then that will would determine what happens in your within your property, with your money, all those things. Now, with that situation, sometimes a will can be there, but then the will doesn't cover everything. So you will die testate and then intestate. Whatever that the will governs will be dealt with by you died without a will. So your property is going to be divided according to different things. For example, if you have a spouse that's living, they get some of that. If you get if you have children, they will also get it. If they have grandchildren, it goes like that. So for example, if you die and you have a spouse, your spouse gets your whatever you left behind. If you don't have a spouse, it goes to your children. If you don't have children yet, if your children have passed on, it will go to their grandchildren. If you don't have grandchildren, it might go to your parents, and then it goes and you might be living on life support, with machines. And that will says, if this happens to me, you can either turn off the machines or whatever the case might be. That living will determines what happens to you when you are still alive, but you are unable to take care of yourself. That will specifically deals with that. A living will does not cancel the will that will be read when you die. The living will deals with what happens when you are still alive. Then the will that will be read when you have passed on is a different will altogether. That is a two the distinction between a living will and a will that will be read when you pass. Let's say, for example, there's a document. There is no specific will, but there's a document that shows that this document was supposed to be a will. Now, this doesn't apply generally. This is according to the court's decision. So if there's a document that shows that this was supposed to be a will, for whatever reason this was not properly done as a will, or all other things, the court can take that will, that document, as the will of the person that was passed on. But that is according the court decides that on a case to case. Let's say there are different wills, and this there are three wills, and in those wills different things have been said about what will happen in the estate, right? If those wills aren't in conflict, all those wills apply. But if the wills are in conflict, the latest will, the newest will be the will that will actually decide what happens with that person's. There are people that cannot inherit in a will, and I'll talk about that. People who, for example, caused your death unlawfully. Somebody who killed you cannot inherit. Somebody who defrauded you to get your money when you die cannot inherit. Somebody who tricks you into you putting them in your will, that person cannot inherit. A person who hides your will when you have passed on cannot inherit. So that is what happens. But let's say you were dying, right? And you asked and your living will says, turn off the machines when I die. And the person who actually does that turns off the machines and all of that. And that person is in your will that will be read when you pass on. That person can inherit because you have specified in your living will that I want this to happen in case of like a situation where I am incapable. You can put different things in a will. Like you can put whatever you want in a will, as long as it's legal and it's not immoral. You can put whatever you want in a will. You can choose whatever happens to your property. Like you should have at least 1.5 to 2,000 rands to draft a will. That's just my estimate. I'm not really sure, but make sure that you get your amounts right. But I'm just giving you like a ballpark amount. But for me, I think it's better like for somebody to go out there and get their wills done, so that like when you pass on, there is no fighting about what happens to your money, to your car, to your property, to your shares. All those things are in this video. Don't forget to comment, like, and subscribe if you like me, the information. If you're learning something, comment, like, and subscribe, and I'll see you guys in the next video. Bye.